everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss the latest updates on immigration, US Citizenship Act, and H1B process and registration. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in a few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice and it is general in nature. It is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. Hi Prashanthi Garu, how are you doing?
Hi Ranjit, I'm good, thanks. How are you?
I'm good. So before starting into the US Citizenship Act that's just introduced last week, could you just give us latest updates on immigration? I believe the visa bulletin, there's a little moment on it, and then we can continue with the other part.
Right, so the March visa bulletin, worth talking about because there's more movement than usual in the March visa bulletin, and that so basically they are using final action dates, so there's no change there. They're not using dates for filing, but the EB1 has moved by 8 months, which is significant, and EB2 has moved by 3 months, and EB3 has also moved by 3 months. So that is a lot more than movement than was expected. So they were expecting a few weeks of movement, but actually now it's a few months. So EB1 is now August 2020, the final action date. EB2 is January 15, 2020, and EB3 is July. So EB2 is January 15, 2010, sorry, and EB3 is July 1, 2010. So those are the dates for March for EB1, 2, and 3. And as I said, final action dates have to be used. So that's, I think, significant in the March visa bulletin from the Indian nationals' point of view. We have to wait and see. There is further discussion on what will happen with priority dates. We were just discussing before the show, Ranjit and me. So since the family-based immigration is still not available, consulates are still closed, Trump's travel ban is still in place until at least March 31st. We're expecting that the family-based numbers and also employment-based for those who are outside the country will not be used the same way as last year. And so we are hoping that there will be some movement going forward also. And in October, we're hoping that the same thing or similar thing that will happen as happened last October when the dates for filing were used. So we're hoping that the same thing will happen. And for those who lost their opportunity, or for those cases that came back, that should present a chance to refile their case. So wait and watch. We will give you all the updates on the show as and when we come to know. So that's I think, update, Ranjit, for the visa bulletin.
That sounds good. We have a caller. Let's take the call and then we can continue. I think the caller is from Texas. Hi. Welcome to the show. Please go ahead and ask your question.
Hi. Hi, everyone. So I have this question. So I have a copy of RFE notice and an approved but unused H1 from 2009 timeframe, 12 years back. So now after 12 years, USCIS website still shows that my H1 from 2009 timeframe is approved, meaning that the H1 was not withdrawn by the consulting company earlier. Also, I have an approved I-140 petition through my L1B visa employment that I got 3 years back. So right now I'm on a H4 visa. So, but I'm getting offer from multiple companies, and I wanted to know if there is any legal way to take this H1, the previous H1 forward. Say, can I take this take any offer and apply for my H1 cap petition along with my approved I-140 petition? Is that doable?
So I-140 has nothing to do with H1. You can file for your H1 as long as you have not used up your total period on your H1. And I think your main question is whether you're cap exempt or not. And if you did not work on a H1 in the last 6 years, as per, definition of cap exempt, then you are not cap exempt, meaning that you have to file your H1, you have to register on March 9th, anytime between March 9th and 25th. And if your case gets picked, then you can file the H1. So you do have to file now under the cap because you were not on a H1 in the last 6 years. So that's why you're not cap exempt.
I hope that answered your question. We have another caller. Let's take the call. Hi, welcome to the show. Please go ahead and ask your question.
Hi, thanks for taking my call. I have two questions. Number one, right now I'm in the process of applying H1B through the CAP. And my question is, there are two employees who are willing to apply for H1. Let's say if both of them are picked and, if both of them are, proceeding to apply for H1, at what point in time, can I pick employer one versus employer two?
So, yes, you can file two H1s as long as it's not the same job. You can file through two different employers as well, as long as the job is different. You file a registration first, which happens from March 9 to 25. And if your case gets picked, then you have 90 days to file the petition. So you can file both petitions, and then what will happen is the last action rule will apply, whereby, whatever petition you filed second, that petition will be your ultimate status unless you withdraw that. Then the previous petition will be, will become your status. Or you can choose which one to file in the 90 days. But the employer might be penalized if they register, they get picked, and they don't file. They have to give a good reason as to, why they didn't file. So those are the parameters that need to be looked at when you file both two registrations.
Understand. Just a follow-up question. So I was in L1A and I was there, I used 4 years in L1A, but, I quit my company in April of 2020, and from there I was in H4. So when I get my H1, say October of 2021, it will be more than a year that I was outside of L1, right? In that case, will I get a fresh 6 years with H1, or will I not get a full 6 years?
You will not get a full 6 years because in order to meet those parameters, you have to be outside the country for a period of 1 year in order to get a fresh 6 years on your H1.
Okay, I was inside the US, but just that I was in a different visa, so I wasn't in L.
Right,
visa,
no, that doesn't help. You have to be outside the country.
Understand. Okay, thanks a lot. Thanks for your answers.
You're welcome.
Okay, that answered the question. Okay, yeah, let's go to the US Citizenship Act, that's just introduced. Could you give me a brief introduction on what it is and how is it going to help the backlog community, and what all the important points that has to be noted with respect to the employment-based immigration?
Right, so I will just touch upon that, employment-based, and briefly for now, and then we can go to the main topic, which is H1B registration. And then if we have time, we can always come back to it, depending on how many calls we get. But so yes, the citizenship.
Sorry to interrupt you, Prashanthi. We have a caller, Kirti from Arizona. Let's take the call and then we can continue. Hi, Kirti. Welcome to the show. Please go ahead and ask your question.
Yeah, hi. So, madam, I had applied for a H1B, change of status from H4, and I got an RFE for my H1B saying that since the H4 has gone for extension, the change of state cannot happen, and I should wait for the H4 to approve or get a counselor H1B approved. So what I did, I went to India, I got my H4 stamping done, and came back and applied for the H1B RFE. And December 28, 2020, my H1B got approved, but we didn't receive the approval copy. The attorney didn't receive the approval copy, and it's going to be almost 2 months. So will I lose my legal status after Feb? And what are the options I have now?
What is the significance of February?
Sorry, madam.
What is the significance of February? Why are you saying you will lose your status after February?
Because it's going to be 60 days. I got the H1 approval on December 28th, 2020. So it's going to be 2 months, end of February. That's why.
So there's several problems here from what you described to me. First of all, you filed a change of status from H4 to H1. You got an RFE saying that, I guess your H4 was pending at the time you filed a change of status. So you got an RFE saying that, wait for the approval. So your attorney, if you had an attorney, should have responded that there's no need to wait for the approval as per the bridging law, and they should have quoted the bridging law. You are in authorized status, and the H1 should be approved because it's not in your hands when the H4 gets approved, right? That is USCIS only. That it's the same body that is asking you for information that they are supposed to have. So we have received RFEs like that, and you always respond. You don't necessarily have to listen to what they say. There is certain laws, and they have to follow those laws as well. So there is something called a bridging petition, and that's what you did. Based on a pending petition, you filed another petition. So that's how you should have responded, number one. Number two, you should not have left the country, because if you leave the country when there is a change of status application, your change of status portion will be denied. So you will get a H1B approval, but it will come without the I-94 attached at the bottom. So the H1B will be approved for consular processing because you left while the petition was pending. So that was not a good way of dealing with the situation. So anyway, now what's going to happen is you're in H4 status anyway, and you continue to be in H4 status. And then when you get the approval, if by some chance you get the I-94, you're fine. If you don't, then you have to leave the country. And if you don't have a H1 visa stamped in your passport, you'll have to go for a visa again. So that's a little bit of a mess that was created due to your travel while the petition was pending.
No, madam, but I traveled because of the RFE, because my H4 was not approved. So I went to India just for the stamping and came back.
But that was wrong. You shouldn't have done that. You shouldn't have traveled and come back on a H4. That kind of messed up your case. Instead, you should have responded to USCIS stating that the petition is with them and the processing times are in their hands, not in your hands, So RFE has a certain defined period of time within which you have to respond. So there's no way, if they don't approve it, what are you going to do, right? So that's unreasonable of them to send an RFE. And they often send that. Anybody would know how to deal with such RFEs. And we have done that in the past and always gotten approvals. So the RFE was wrong and they should have responded appropriately, quoting the law. The response to the RFE was not leaving the country. When you file a change of status, if you leave, then your change of status application is automatically gets denied. They cannot approve it.
But my H4 also got approved, and I got an updated I-94 for the H4 also.
Yes, but you left the country while the petition was pending. Now it got approved, I understand. But while the petition is pending, you should not have left the country. Now I'm worried that they will approve your case only for consular processing and not a change of status, if they become aware of the fact that you left. So wait and see what the situation is. And I don't know why you didn't get an approval. That seems to be your main concern, but you have other reasons, other things to be concerned about. But not getting an approval then is you just have to call, you're not out of status. You just have to call, well, you're not out of status because you don't know whether the H1 has been approved with an I-94 or not. So you can't really start working until you have proof of that, right? So I understand that 60-day concern that you have, but I have a bigger concern than that. So it's important to anyway get that approval. So if it's premium processing, it's easy to contact premium processing office. If it's regular processing, it's still easy. They do respond. So it's easy to contact them and contact them several times if necessary. Or if all else fails, file a duplicate petition if the petition was lost. But you need to get a response on, see what that approval is, whether it has an I-94 or not.
Okay, I hope that answered the question. We have another caller, Manoj from Atlanta. Hi, Manoj. Welcome to the show. Please Go ahead and ask your
Hey,
question.
yeah, can you hear me well?
Yes, please.
Hello? Yeah, ma'am, I have a son which is minor, and his H4 is expiring in next 6 or 7 months. But my H4 is, I'm also in H4. My H4 is till next 1 year, 1.5 year. So if I go to cross the border, and can my son get his I-94 extended, or we have to go for stamping?
So in order to extend status, anybody's status, you have to file for an extension. If you want to do this while you're in the US.
No, we have that.
Or,
We have that
or
actually.
you
We have
can
that
do it
later.
by leaving the country. But if you leave the country and if you want to come back in, you need to have a visa. If you do not have a visa, then you cannot come back into the country. So I hope that answers your question. You need a visa. If you're leaving the country, if you want to file an extension here, then you don't have to worry about a visa. You can file your I-94 extension here.
Yeah, Prashanthi, we are talking about the U.S. Citizenship Act that's just introduced. Could you just give a brief, and then we'll go to our regular topic of H1B registration process?
Right. So the first thing is that they are going to recapture the immigrant visas that were lost due to bureaucratic delays. So there are a lot of visa numbers that were remained unused over the years, and there's always been a talk about making use of those visa numbers that were never used, and thereby increasing the count. So one of the proposed rule is that the unused visa numbers be used. So for family-based visa numbers, that will effectively increase the cap from 226,000 to 480,000, almost doubling it. And for employment-based, using of the unused visa numbers will increase it from 140,000 to 170,000. So that's one thing, reusing the unused visa numbers, and they're going to, if the bill gets passed, then this will be effective from October 1st, 2021. The second thing that they're going to do is they're going to make children and spouses of permanent residents as immediate relatives. What happens in this, if they do this, is then a visa number is not required, because for all immediate relative categories, for example, if you are married to a US citizen or you have US citizen parents that you're filing for, these are all immediate, or children, US citizen, you're a US citizen and filing for your children. So these are immediate relative IR categories, and visa numbers are never needed for them. So they're going to make permanent resident children and spouses also, minor children and spouses also, into that immediate relative box. They're going to put it into that box, and so visa numbers won't be needed. They can immediately get their children and spouses into the country, or adjust their status here in the country. So that will open up also more visa numbers for the other categories. So that's a good thing. And also the family-based numbers will now be expressed in the form of percentages. So rather than giving a number, they'll say 26% is allocated for family-based category 1, 16% for family-based category 2, so on and so forth. So they're going to, rather than giving a number, they're going to say that this much percentage is allocated to each section. So that, I think, gives it a better description as to how much, what is available. Per country, adjustment of family-sponsored per country limits are being raised. For family-based, again, we're talking about family-based petitions. Per country used to be 7%. Now each country will get 20% of the total number. So that's a good thing. It's increasing from 7% to 20%. And also another good thing is that in order to promote family unity, that keeping the families together, they're going to remove this horrible 3 to 10 year bar law that came up in 2007, where it says that if you overstayed for 180 days, and if you leave the country, then you cannot come back for a period of 3 to 10 years, depending on how long you overstayed. So that is being removed completely. So even if someone fell out of status, they can leave and again, try to rectify their status and come back into the US. Another relief is for widows, widowers, and orphans. Even if they're, so example, they file a family-based petition and the petitioner dies, they can continue to get their green card. So that's a good thing. And then the other update is retention of priority dates. So even if a child ages out, they continue to retain that priority date that they had. So they can file another petition on their own through family again or through employment based, and they can retain that priority date. So that's very significant because if they have like a 2010 priority date through their family based petition, and then as a student they file an employment based petition through their employer files an I-140, the old priority date of the I-130 can be retained, which is great because it gives a lot of flexibility then and decreases the amount of stay for that person who aged out. Also, they have, I'm just trying to see what is relevant here and just talk about the relevant points. And we can go into more details later. So the other thing is STEM graduates. So people who earn a doctoral degree, that's a PhD in science, technology, engineering, or mathematics, from an accredited US university are not subject to numerical limits. This is great, right? Because then that opens up the numerical limits and creates more and allows people with advanced degrees or PhDs to immediately adjust. So this is really great news for employment-based immigration. And for those who are suffering from visa backlogs, and if your priority date is more than 10 years old, you will not be subject to the numerical limit, so you can immediately adjust. As soon as it becomes 10 years old or more, the priority date, immediately adjustment will be available for you. So that is also great news for those who have been waiting for many years and people who may not get the benefit even after adding and even after all these other benefits have been added. If they're still backlogged, then they can automatically adjust if their visa numbers are over 10 years old. Most importantly, the other thing that they're doing is eliminates employment-based country caps. Very important for countries like India and China that are severely backlogged, and it takes 10 plus years to get visas for these countries, while other countries, they can get it immediately or maybe with a wait of a few years. So they're completely removing allocation per country and making it open for everyone so that it's just first come, first serve. They're also increasing the employment-based numbers for EB3 and other workers by 30,000. That's significant. So not only are they making it more equitable and keeping it free of nationality, so that those other people who were ahead because they belong to a certain nationality, they're trying to make sure that they don't get backlogged by increasing the number of visas or doing other things so that everybody's treated fairly and they don't then become backlogged. Then that will not that defeats the purpose. And whenever needed, because they have to always have safeguards and they can't have open visa numbers and people getting green cards when the economy is not good and people already in the country are not getting employed, they always have the ability to be flexible with reference to the EB2 and EB3 visa numbers. So they've put in that flexibility whereby they can, DOL and DHS will establish a procedure to limit the EB2 and EB3 visa numbers if there is some kind of a crisis with reference to unemployment. Also, with reference to in order to improve the economic development of certain areas, they're creating a new visa pilot program where they'll give 10,000 visas for those people whose employment is essential to the economic development of those underserved areas. So that's another category that they're including. And they also want to include a wage-based consideration for H1s. This is not a very good news. So we've been hearing that also there is right now also a regulation which has been postponed, but basically they want to include a wage-based consideration to prioritize the lottery system. So that has been postponed to the end of December to see how it can be done fairly. So basically what they're saying is level 4 wages should get the first shot at the lottery, and then level 3, level 2, level 1, etc. I guess the new administration also wants to look into that. So that's why they've put this in the legislature, in the bill itself, to take a look at it. Another important section is F1s. Presently, F1s don't have a dual intent, which means that if you're on F1 status, you can't file a green card. And if you file a green card on I-140 and I-130 or a 485, then it becomes difficult for you to maintain your F1 status. So they're removing that intent to immigrate and making F1 also dual intent, just as a H1 is dual intent, which is very good because that's the only way it will facilitate students to actually apply directly for a green card without having to go through a H1. And as we discussed earlier, PhD students in STEM will not be subject to the caps anymore and can apply immediately for a green card. So that wouldn't have been possible if they didn't remove the dual intent provision on the F1s. Also with reference to H4s, we've noticed that often, because it's taking so many years for parents to get green cards, children are aging out. So on a H4, you can't stay. You can only stay until you're 21. You cannot stay on a H4 beyond 21. So children are having to either leave the country or file for some kind of a change of status to perhaps a student status and have their own status. And this doesn't promote family unity because they might have to leave while the rest of the family is still here. So in order to avoid that, H4 children may extend their status beyond the age of 21 if the parent is maintaining his or her status and the child was younger than 18 when he first gained non-immigrant status. So as long as he got his H4 before he was 18, they can continue being on H4 even after they turn 21. So that's another good thing, I think. And H4 spouses and children are eligible for EADs, right? So I think they're now making all H4 spouses and children eligible for EADs. So that's another. So we don't know how much of this is going to actually become law, but there are a lot of good things in here. So hopefully at least some of these sections will be retained. The other thing, I think that is pretty much it with reference to the visa number availability. And if we have time, we can discuss the rest of the bill because it's quite large. Raj or Ranjit, or we can go into the registration part now.
We just have a caller, Kalaivani from Texas. Let's just take the call and then we can continue. Hi, Kalaivani. Please go ahead and ask your question.
Thank you. Hi, Prashanthi. I got a second RFE for my I-140. Just wondering what kind of RFEs we get for I-140 nowadays. First case, will I be able to extend my stay for one more year using my perm? What are my options here? I'm nearing my 6 years. That's why I'm worried.
Yeah, if you file your perm 365 days before the expiry of your 6 years, then yes, you will, instead of getting that 3 years, you'll at least get the 1 year extension, which should be enough time to be able to respond to your I-140 and get it approved or whatever the situation might be. RFE can be anything, but usually RFEs for an I-140 are either ability to pay, number one, or it could be something with reference to your degree or something with reference to your experience. So your qualifications. So it can be something with reference to qualifications, or it can be with reference to the ability to pay. It could be either one. For example, if you say the requirement, if the labor cert said the requirement is a bachelor's degree plus 2 years of experience or something like that, and you have a 3 years bachelor's degree, you don't have a 4-year bachelor's degree, they could be sending a RFE on that. Or if your bachelor's, you have a degree, but it's not from an accredited, it was not accredited at the time that you received the degree, then they could have questions about that. If you didn't submit an evaluation, and if it's a foreign degree, then they could have questions about that as well. If you've asked for experience or you've asked for certain skills in the perm, and those skills are not visible anywhere, they don't know where you acquired those skills or whether you have them or not, or some certification, then they can ask for that as well if it was not submitted. So, and of course, the ability to pay issue, you might already know, the employer has to show that they have the ability to pay the prevailing wage as of the date of filing the labor. So what is already being paid through your W-2 will be deducted, and if there is still a gap between what was paid to you and the prevailing wage, then they want to see that money in the employer's tax return, either through taxable income or via assets, net current assets. So those are the two most common, I think, RFEs that you get in an I-140.
Yeah, thank you, Prashanthi.
I hope that answered your question. Okay, Prashanthi, we can get into the H1B registration process. Could you just give a brief introduction of what is the H1B registration process, and then we can get into some questions.
Right. So like as discussed last time, we kind of touched upon what is the H1B registration process and what information is needed. But just to recap for those who missed last week's episode, since last year, the USCIS has been conducting this H1B registration process. It's kind of, instead of filing the entire petition with USCIS and then them returning completed packages and doing a lottery based on those packages and then returning the packages that didn't make it in the lottery, that wasted a lot of money and effort and time because you had to send out completed packages. So now they've come up with a pre-registration process whereby you can go online, open an account, and register yourself for the lottery. So you have to enter some basic fields of information such as name of the company, address of the company, FEIN number, beneficiary's name, date of birth, passport number, whether it's a master's or your US, whether you're applying under master's cap or bachelor's cap. And then based on that online form, they will do the registration. They will do the lottery system based on that registration that you do. And then once the lottery is done, which is usually done between the 25th and the 1st, that's after the registration is over. The registration starts on March 9th this year and ends on 25th. So from 26th to 1st, they'll conduct the lottery and then they'll send the results. So by April 1st, all the results should be out, and they'll send that via email, or you can log into that same portal that you registered in, and they will let you know whether the case was picked under the lottery or not picked. So once you get a receipt from them that it was picked, they will also send in that receipt the USCIS address, the office that needs to be sent to. So there's a specific address. This is not the usual filing addresses that you find on the USCIS website. You have to send it exactly to that address which they ask you to send it to on the receipt. So and they give you 90 days to send out that picked H1. So now when you're sending it out, you have to send out the entire H1 with the I-129 forms, LCA, and the entire package, and show how the person qualifies or what job is available for the person. So this is the process this year, and it was the same last year as well. And for those people who register but the case gets picked but they don't file, there are some issues with that, because they might say that you used up a number and you haven't filed, so they want to discourage that. So if they find that there's a pattern of doing that, one company is doing that in a lot of cases, they might open some kind of an investigation or ask questions about it. So you have to have proper responses as to why you didn't file, and valid responses. Also duplicate filings. Again, people are trying to get as many picks as possible in the lottery, so they file duplicate petitions. Duplicate petitions are allowed as long as it's the different employer. One beneficiary can file 2 petitions, but the same employer cannot file 2 petitions for the same beneficiary. And if it's 2 different petitioners, then again they cannot again file, because again it's difficult, because if they cannot file, because if it's the same job and 2 people are trying to file the same H1, it becomes a problem. So just briefly on H1B registration.
Yeah, Prashanthi. So the H1B registration process have lots of things involved. One thing is, I believe it doesn't have any work location on it. So do you mean that people can file for the same work location 2 petitions or more than 2 petitions, because there's no such thing in the registration process, and how those things can be handled, and what are all other complications? If you could explain.
Right. So basically, that's true. There is no work location that has to be mentioned in the registration. It's only basic information that's needed. The basic information is with reference to registration is the address of the employer, as I said, the beneficiary information, date of birth, the passport copy. So you're not actually mentioning anything about the job or whether you have work for that person or not. So this is something, maybe a loophole that companies might use to first register and then actually look for a job for that person if they get picked, rather than having a ready-made job for the person, because you don't have to show that you have an offer of employment or a bona fide job at the time of registration, because there's no column to fill out. You have to show that at the time of filing the H1B though. As we noted, there's 90 days to file the H1B. So it's quite possible that people will file a speculative registration and they will wait and see if the case gets picked or not. And then if the case is picked, they still have 90 days to file the petition, then so they could still, technically look for a job then, at least theoretically look for a job and then file the petition, because there's no workplace really mentioned in the form. So this, I'm not sure what complications it can cause. I guess the complication is that if you file a speculative registration and if it gets picked, and if you're not able to file the H1 because you don't have a job offer, and say you did this in 10 cases, USCIS can come after you. You have to have a valid reason as to why you really didn't file. So this is something that has to be really looked into carefully. I think there are many other complications with reference to the H1B registration process. The other complication is duplicate filings, as we were talking about earlier. If the same company files 2 cases, of course, that is a duplicate filing. Or if it's actually 2 separate companies, but maybe they're sister concerns, which means, same common ownership. So one person, Mr. A, owns 2 companies, and through both his companies, he files for all of his employees. So that's clearly a duplicate because there's a relationship between the two companies, so that those are considered to be duplicates. But how are they going to know whether a particular petition is a duplicate or not? So basically what's going to happen is if two cases are picked, both the cases are picked at the same time, and if both are filed, then it's possible that there'll be an RFE on both the cases. And once you get an RFE, then it's easy to find out, right? Whether maybe the address is the same for both the companies. Maybe the ownership, if it's the same, then maybe it's the same signature. So there are many ways of finding out once the petition is picked and you file an entire petition that both the employers are connected. And that has happened last year. And both petitions got denied, actually, because they filed through separate attorneys. And unfortunately, that person got picked twice. But both his petitions got denied because of the duplicate filing, Ranjit. So duplicate filing is something that we have to be careful with.
Yeah, got it. So apart from the duplicate filings, how the company should especially be aware of, especially a lot of companies have sister concerns and, other kind of relation. So can they apply from two of such companies?
Right. So I was just saying that, the related companies, if they find out, it's a problem. If they don't find out, well, I guess, it's not a problem. So it's really depends on how much investigation USCIS does in it. But as I was mentioning earlier, sister companies cannot file for the same beneficiary. It's considered to be a duplicate.
Got it. So can they update the details on the registration once it is submitted? Is there any such option?
No, so you have to be very careful when you file the registration, because if you make some mistake, you cannot again go back and change that registration. So once it's submitted, it's done. You cannot make any changes to the registration. But however, if there is some typo or some mistake, when you're filing the H1B, that's the time to rectify your error. So in the I-129 petition, when you're filing it, you have to put a cover letter saying that, registration has this address, but the employer address is actually this, the suite number is wrong, and this was a typographical error. And to prove that this is the correct suite number, please see the copy of the lease. I'm just giving you one example of how a typographical error can be corrected.
Yeah, how will USCIS address a scenario where the prospective employer with selected registration puts an address on the registration but moves before filing their I-129 petition? The address and the registration is different, and I-129. How can they handle such situations?
Right. This is it is a problem if it's not addressed. So it has to be addressed properly. Once you move the address, if you move your address, so then you have to make sure that when you're filing the I-129 petition, you write a cover letter and make sure you put it on top of your filing. And in the cover letter, you mention that the address has changed. You show proof of change of address. You show the new lease. You show the tax returns, whatever proof of address you have to show that the address has actually changed. So as long as you address that and don't ignore it, it shouldn't be an issue. And you should be able to document that change of address as well.
Got it. Okay, we have a caller, Sandeep. Let's take the call and then we can continue. Hi, Sandeep, welcome to the show. Please go ahead and ask your question.
Hello, ma'am. How are you doing today?
Good, thanks.
Yeah, ma'am. We filed for H4 EAD in month of November, and we did not get the receipt till today. And when we called to USCIS, they asked to send the email to the lockbox. We had already a biometrics, and we got H4 approval last month for my wife. Okay, so we are waiting for H4 EAD approval. So again, we have to go for biometrics for H4 EAD also again, or one-time biometrics is fine for the H4?
One biometrics is sufficient. You don't have to go over and over again for biometrics. If you've given it for your H4, because both were filed parallelly, then you don't have to again go for biometrics for H4 EAD. As you know, H4 EAD is being delayed, and there is a lot of concern about that. Court cases are being filed, a lot of litigation pending. AILA, which is American Immigration Lawyers Association, Ombudsman's Office, everybody's involved in this delay, in trying to sort out this delay. So it's taking 8+ months in some cases to get the EAD. So you can do your best, try to expedite your case, approach your congressman. Otherwise, you just have to wait, or you can litigate like some people are doing, file a mandamus petition. But you cannot litigate unless the processing time has passed. So I don't think it makes sense to litigate if it's less than 6 months that your EAD has been pending. So if that after that 6 months period also, if you don't get an approval, then that's another option.
Okay, thanks for the call. Prashanthi, we are towards the end of the show. Let's continue the session next time. Again, thanks for everyone for calling and watching the show. It's a great session with interesting topics and questions. Please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. It's again every Wednesday, 5:30 p.m. EST on Sakshi TV. This is Ranjit signing off.